From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. On Thursday, the Supreme Court said it would take up President Biden's student loan forgiveness plan. And just to set the table here a little bit, recall that it had been blocked by an appellate court. The Justice Department had asked the Supreme Court to clear that block. And instead, the Supreme Court is saying that we will hear this case oral argument in February, which means that a ruling is likely by the end of June, which is when the court generally wraps up its term. Colin, how do you read this? I mean, to my eye, it suggests that it's a real loss coming for the Biden administration and probably a win for the critics of this forgiveness plan.
Yeah, I mean, I think that's probably what you're going to see here. When you look at this loan forgiveness program to begin with, the administration is really hanging its entire hat on the executive power and on this idea that there's this emergency provision in a time of war that allows the education department to waive or modify any existing loans. And we have to remember that in the context that it was written, this is back in 2003, we're in the middle of a war in Iraq and Afghanistan, and you really had it done so that the education department could, waive loan payments or do forgiveness for people who were signing up for service. So the fact that it's being used the way it is, I think, is, to begin with, an incredibly cynical exercise. And when you actually get into the court case that we're going to look at, I think that it's going to be quite an interesting thing to watch the administration try to defend that. I think the administration probably knew that. I mean, I think they probably knew they didn't have a case when they did this. And, in a way, that's sort of the worst of it, because there's a lot of people out there who think their loans may be gone forever, and probably a lot of them have made financial commitments or other plans for that money. And they're now going to find out that they're really up a creek. But by the time that comes around, guess what? The administration is going to be able to say, well, guess what? It's all the Supreme Court's fault. It's those Republican appointees on the Supreme Court. And therefore, somehow this is, an illegitimate decision. So it's, cynical even by Washington standards, I think.
I agree. It will be fascinating to watch them try to defend this. It is a great example of motivated reasoning, I think, in Washington. I mean, Speaker Nancy Pelosi famously had this quote where she said, obviously, the president doesn't have the ability to forgive student loans. Congress has to do that. Here is the Pelosi statement on President Biden's historic student debt relief from August 24, 2022. She calls it bold action, a strong step in Democrats' fight to expand access to higher education and empower every American to reach fulfillment. What's notable, though, it's always hazardous to try to predict, Kim, what the Supreme Court is going to do. But it takes 4 votes to take a case. And if the court disagreed with the appeals court's judgment that the parties here had standing, or that the student loan forgiveness plan ought to be blocked, it could have just vacated that injunction. And so the fact that they're choosing to take up this case, take it up not on the emergency docket, but take it up in more or less regular order and put it on the oral argument calendar for February and issue a decision this term, I think suggests maybe that something bigger is in the offing.
I couldn't agree more. As you said, they could simply have vacated the decision here by the Eighth Circuit. And just a little background there, the crux of this case are 6 states with Republican governors who have sued. And in these states, they have these somewhat quasi-governmental organizations that administer their own loan programs or jointly do. And they have made the argument that the state will suffer financial consequences as a result of this issue and therefore can prove an injury. The Eighth Circuit certainly accepted that as grounds for standing. And that has been one of the big debates in some of this litigation. There have been some other courts that have ruled the other potential plaintiffs who made an argument against this did not have standing. But the Supreme Court here seems to have accepted that there is a certain level of validity to it. And as you said, they're doing it on regular order, but they are doing it at the request of the Department of Justice. So the arguments will be heard in February. One more cynical aspect of this, though, and it's really quite astounding, is that the administration has continued to extend the moratorium on repayments That was due to end in January. It is now said that it will not end until 60 days after the resolution of litigation. Well, that could be quite some time, because if the Supreme Court does hear oral arguments in February, and they are doing this more quickly than they might otherwise, they took the case directly rather than having a continued fight over it down at the circuit level. They may not issue an opinion, especially if it's a biggie. The usual Supreme Court strategy is you don't release those big decisions until the very end of term, which is in June. And so even though it's very good that the court is doing this, and I really applaud them for stepping in, taxpayers are still getting shafted here because they're continuing to lose out on all of the revenue that should be coming in from loan payments, whereas the administration is using every excuse it can, whether it was COVID emergency, now litigation, to extend this moratorium on ad infinitum.
Colin, I agree with you wholeheartedly that if the Biden administration loses here, President Biden will probably say this is an illegitimate decision by a packed Supreme Court. We've heard a lot of that over the past 2 years, and I expect we will hear more of it over the next 2 years. But do you think voters will accept that, and particularly voters who have student loans and started counting on this? I mean, maybe some of it depends on how the decision breaks down. But if you get a 7-2 decision or an 8-1 decision, that this is obviously a separation of powers concern, and Congress did not appropriate this hundreds of billions of dollars to student loan forgiveness, do you think there are any of these voters who will say, wow, President Biden, he wrote me a check and he knew he couldn't cash it, and if he had listened to the best legal advice, he wouldn't have done that. And now I've lost out on the forgiveness that I was counting on, and it's not the Supreme Court's fault, it's his fault.
I think it would be great if that happened. Unfortunately, I think that's might be a little bit of wishful thinking, because I think at the moment that a decision like that comes down, all the fingers are likely to point directly at the Supreme Court and play into a lot of Democrats' ads that, this was taken away from you and we did our best to get you this forgiveness, and look at the Supreme Court and what they've done now. I think, Kim mentioned the standing issue in the court, and I think that is one thing that probably the administration is hoping maybe it could manage to pick off a couple of justices on that and say, well, I think Missouri is the state that has actually like a state-based loan program and therefore very direct injury. But if they could just manage to pick off one of the justices on the standing issue, then they could sort of be going on a more narrow basis and maybe be a little bit less controversial. But anyway, I hope that your scenario could play out, but I'm not sure that voters' memories are that long, especially when their pocketbooks are suddenly a little bit more empty than they expected.
Thank you, Colin and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we will be back next week with another edition of Potomac Watch.